Ray Churchill. I'm an attorney from here in Fremont. And this is a great event, Senior Resources Fair. We want to thank CAPS for inviting us all here. A lot of good information. To ask everyone, if you haven't done so, we're going to be giving out a gift basket. So if you want to sign up for our drawing, back at the table there. We are here to talk about living trust. One of the things that I often tell my wife about is that when you see a funeral, you can see funerals in town. They go down Maury Street or down Fremont Boulevard, and you'll see the hearse that's always leading the funerals. And one of the things that I commented on with my wife is that whenever you see the funeral, you see the hearse, you never see the hearse pulling a U-Haul, meaning you can't take things with you when you go. So we're all going to leave this place, right? And so it's important that we have things ready. So one of the ways to do that is with the living trust. What is a living trust? Well, a living trust is a written legal document. And with that document, you take your assets, you can take your home, you can take your stocks, you can take your bonds, your bank account, and you can put them into that trust so that they're administered during your lifetime, and then when you die, those assets are given to the people that you want to get those assets. Some of the people that are involved in it, of course, it's your assets, but one of the terms is a trustee. Has anyone heard the term trustee before? A trustee of the trust is a person, usually most people who have trust, they are the trustee themselves, which they like that because that way they can stay in control of everything. And then you can also have what's called a successor trustee. A successor trustee is the person that takes over when the original trustee doesn't act as trustee. When they're unable or they die, then you have what's called a successor trustee. Now, as I mentioned, the living trust is an agreement. It's a legal document, usually prepared by a lawyer. And that document gives the trustee the legal control over all of the assets that are in the trust. And I like to think of a trust as a basket. And you've got this basket and you put things into it. You put your house, you put your stocks, your bonds, and then the trustee has the legal control or the legal authority over everything that's in that basket or in that trust. So it's a very important position. The trust also gives the trustee instructions as to what to do with the assets that are in the trust. And it also gives them guidance as to certain things that the money can be spent for and other instructions. The trust also names what's called beneficiaries. Now, the beneficiaries are the people who are going to receive the benefit of the assets in the trust. And if you create your own trust, you're actually doing three different things. You actually own the trust, you're the trustee, and you're also the beneficiary, meaning that all the money in the trust is going to be spent for your benefit. Now, it doesn't have to be like that. Other people can be beneficiaries. You can have your children as beneficiaries or other people as beneficiaries, but the beneficiaries are the people that are going to receive the income and principal out of the trust. Now, some people say, if I'm going to have a trustee, is that risky? Is the trustee going to have too much control over my assets? No. It's important to know that a trustee is what's called a fiduciary. And what that means is that they're held to a very high standard by the law. And so they have to be honest. They can't use the money for their own personal benefit, the trustee has to use the money for the benefit of the people who are the beneficiaries. So that's important. But a trustee has to be somebody that you can trust. That's why they call it trust. Why do people have living trusts? Well, the most common reason that people have a living trust is to avoid what's called probate. Anybody heard of probate? Anybody been involved in a probate before? Somebody say yeah. It wasn't a pleasant experience, was it? No, usually not. Probate is a process where it's supervised by the courts. So first of all, you're involved in a court proceeding. And so when somebody dies, if they have a will, or if they don't have a will, and they have enough property, then their estate has to go through what's called probate. And so that's again, it's a court proceeding where the will is submitted to the court. Someone, usually a family member, or if it's a will, the executor that's named in the will, goes to the court and they file what's called a petition. And then there's a hearing that's noticed, and after the hearing, the judge is going to usually accept the will and also nominate someone as the executor of the will. But that doesn't end everything. The executor then has some responsibilities. They have to do what's called an inventory. So they have to do an inventory and get the assets appraised. They have to contact all the creditors of the decedent and give them an opportunity to get their bills paid, their debts paid. But at the end of that whole process, the court's going to issue what's called a final order, and they're going to order that the money be distributed to the beneficiaries that are in the will, if there is a will. Some of the problems with probate, why people want to avoid it. First of all, it's a court proceeding, so a lot of people don't like to go to court. It can be expensive because you've got to pay not only the filing fees, you've got to pay executor fees, you've got a publication fee for newspapers, you're paying a fee for attorneys, you're paying a fee for the executor, and so all those fees add up. The other issue is that it's a public proceeding. I know whenever I file a probate, I get calls from my clients. They say, oh, all of a sudden I got a call from a real estate person. I got a call from this person or that person. They're asking me about, what's going on. How do they find that out? Well, it's public because everything is published in the newspaper, and the petition that you file is a matter of public record. So it's a public proceeding. That can be a problem for people. And also, it can be a costly proceeding. There's a schedule that you use to figure out how much you pay for probates, and for a modest estate of $400,000, the fees and costs could be $23,000 or more. The other problem that people have with the probate is that it can take time.